Well, judgment's been reserved in the matter of Jacob Zuma and President Cyril Ramaphosa. A full bench of judges in the South Gauteng High Court also dismissed the notion that former President Jacob Zuma had been treated unfairly during his legal challenge against his private prosecution bid. Zuma had lodged a complaint at the court for the shortening of his allocated time for his legal team to present arguments. Zuma is accusing Ramaphosa of failing to act against prosecutor advocate Billy Downer for the alleged disclosure of his medical records. SABC News reporter Canny Maphanga was there and joins us now. Canny, good evening to you and welcome. So let's start with this notion that the former president has of his defense team being robbed of time. How does that measure up to what actually happened in court, especially vis-a-vis the conduct of his senior counsel, advocate Mpofu?
Well, good afternoon to you and the viewers at home. Well, the judges did place it on record how much time they actually did have, and it came out that it was an hour and 30 minutes more than what the other counsel had used. So what we understand is that advocate Mpofu, was supposed to argue until 11, and at 11:30 p.m. he was still submitting most of his arguments. So he was cut short at that time. The client, which is the former President Jacob Zuma, who is in attendance, who was rather in attendance at the proceedings, was aggrieved by that, saying that he really wanted to place his arguments on record. Of course, you know, they file papers before you head to arguments, but his main contention was that he felt that his time rather had been cut short as the respondent in the matter. So we had that mini application that took place for request for further time, and the full bench explained why they couldn't grant that request. We were supposed to finish today at 1. We ended up only finishing at around 3. And there were still replies. There was still another argument by the amicus, so they refused that request, saying that they had been accommodating of the respondents regarding their arguments made in this highly publicized application.
If we had to go to the guts of this, I mean, what it seems to be about is that former President Jacob Zuma wants jail time for President Cyril Ramaphosa, and Ramaphosa wants this pursuit of him to end. Who seems to be on the cusp of getting what they want in this matter?
Well, I'm not sure that I would phrase it as jail time. I think the common theme that we always go back to is this alleged disclosure of the health records and the former president seeking justice regarding that, and him feeling aggrieved with the argument or the fact, whichever way you want to put it, that the president did not handle or heed to his request to establish a commission of inquiry into the alleged conduct of the senior prosecutor, which he believes compromised the NPA and by extension the criminal justice system as a whole. So I don't think the end goal is jail time here, but you could start talking about political motives if you wanted to, but the end goal, I think, is to pursue justice. And of course, there are arguments that we've seen out there by analysts regarding the corruption trial itself and the bearing that these different applications have on that as well.
Well, you mentioned the NPA and this notion or the concept of the independence of the NPA, also, you know, a theme that's arisen. Tell us more about that.
Well, the independence rather of the NPA is an issue that came out by the amicus today when they were discussing this issue. There was an amicus that came to bring forward.
And this is the friend of the court. The
friend of the court, yes. They came to bring an argument regarding this issue, not for the president or against, or not for former President Jacob Zuma or against, but rather this issue of protecting the independence of the NPA and how private prosecutions can safeguard that. So we've seen the bench questioning this process surrounding this issue of the private prosecution of President Ramaphosa. They've raised that statement that came out in December of last year, which could have been perceived as something that could have tainted the process, because it was someone from the head NPA office clarifying on behalf of the DPP and KZN that those nollie prosecute certificates that were issued had nothing to do with the president. And this was a matter between a private individual and the president, and we saw the heads of the NPA coming in to intervene, I guess, if that's the perception, by issuing out that statement. And we had Justice Ishmael asking, I mean, why did they get involved to that extent? So that was quite an interesting theme at the end, or the tail end, of the closing arguments today in proceedings that discuss the independence of the NPA, and not just if you take the president out of the equation, just when you speak of high-profile politicians, names, businessmen, etc., that the NPA would be required to prosecute, and the challenges surrounding that.
We'll have some legal analysis on this issue of the nolli prosequi. On substantive, substantive matters, the reason we're in court, where do things stand now? Judgment is reserved. When is a decision likely to be made?
Well, the clerks and the full bench will communicate when that judgment is ready. So as of now, we know that in a few weeks' time, we have to go back to the criminal court. As I've explained, we do have a situation where there are parallel hearings over the same issue. Now, if there isn't a judgment or this matter has not been finalized by the time we have to go back to the criminal court, we can expect another postponement regarding that. And then pending the outcome of this application, we will then know what will take place regarding that private prosecution bid that the former president is pursuing.
Canny Maphanga, still a long road to travel. Thank you for giving us an update of developments coming out of the South Gauteng High Court.